Hello and welcome to Virtual Patent Gateway's PTAB Practitioner Series. Today's session is the evolving practice of discretionary institutions based on parallel litigation, strategies for addressing Fintiv challenges before the PTAB. Hosted by Virtual Patent Gateway and led by Jonathan Bowser and Angela Oliver of Haynes and Boone LLP. Virtual Patent Gateway founder Ashley Chung has a passion for supporting women in the workplace and is committed to developing a growth mindset within VPG. Jonathan Bowser is a registered patent attorney focusing on patent litigation disputes before the Patent Trial and Appeal Board and federal district courts. He has been counsel in more than 100 AIA trials before the PTAB, representing both patent challengers and patent owners, and litigates appeals before the U.S. Court of Appeals for the Federal Circuit. Angela Oliver is an appellate and intellectual property attorney who focuses her practice on appeals before the U.S. Court of Appeals for the Federal Circuit, federal district court litigation, and post-grant proceedings before the U.S. Patent and Trademark Office. This webinar will be recorded for future use, and we have applied for 1 hour of Virginia CLE. Ashley will notify you when it is approved. There will be a short Q&A at the end of the presentation. And with that, I'll hand it over to Jonathan.
Well, thank you everyone for joining us. And as mentioned, we're going to be talking about strategies to address Fintiv challenges before the PTAB. And to kick us off, my colleague Angela is going to get us started.
Okay, thanks, John. So if we can switch to the next slide, we're just going to give you an overview of what we're going to cover today. Essentially, we're going to just kind of provide an overview for those who are not familiar on the background of Fintiv and kind of the purposes underlying Fintiv. And then the next thing we'll cover is how the practice surrounding Fintiv has evolved over the years. There's been a large number of shifts in what's been going on, and so we'll talk about that. One of those shifts is the use of stipulations in IPR petitions. And so we'll talk a little bit about those and about the effectiveness of those stipulations as well. And then we'll wrap up by talking about recent trends in Fintiv-based discretionary institution, and we'll talk through some particular practice tips for both petitioners and patent owners. Okay, so if we can switch to the next slide, we'll start by taking a step back and looking at how the practice of discretionary institution has evolved over the years. So this chart goes back to, let's see, you can switch to one slide before, sorry about that. Okay, so going back to 2018, we can start by saying this was not common back at that point in time, but you can see it's dramatically increased since then. Up to in 2021, over a third of decisions are addressing these kind of discretionary factors. And let me begin by saying that we're talking about Fintiv. That's kind of the focus of today's presentation. But of course, Fintiv is not the only reason for discretionary denial. There are other reasons as well. And so this chart kind of incorporates the broader practice of discretionary institution. We'll talk about some of those other reasons briefly, but just know that this Fintiv is not the only thing to consider when you're looking at discretionary institution. Okay, now let's switch to the next slide. Okay, so again, looking at kind of the historical trends, you can see over the past few years, there's been an increasing number of decisions where the board has exercised discretion to deny institution. And you can really see in 2019 and 2020 that there were almost half of the cases in both of those years where this was an issue. The number of denials was particularly high in 2020, 196 cases denied based on these kind of factors. And as we'll see throughout this presentation, this uptick in 2020 was largely the result of the new precedential decisions that had come out in 2019, in the middle of 2019, and then in early 2020, that really focused and shift the focus on the parallel litigation and this Fintiv analysis that we'll be talking about. So then you can see at the end of this chart in 2021 that things have stabilized a little bit more. So the trend is shifting again. And there may be a variety of reasons for this, but one of the big reasons is that parties have just become a little more savvy. Parties have adapted and learned how to deal with Fintiv, And so from day one, when you're considering looking at filing an IPR petition, people are thinking about Fintiv and other factors as well, and looking at how they're going to address that to make sure their case is instituted. Okay, we can jump to the next slide. So diving in just a little deeper into what exactly is going on with discretionary denials, the primary statute that permits discretionary institution is Section 314A. And that provides that the board may not institute an IPR unless the petition shows a reasonable likelihood of prevailing. But the statute does not require the board to institute if it finds a reasonable likelihood. And that's how the Federal Circuit has interpreted this statute. You can see we've included a quote here from a fairly recent Federal Circuit case that emphasizes that the director is permitted but never compelled to institute an IPR. And so because of this, there have developed a variety of reasons that the board may deny institution. So we've listed some of them here on the slide. The first one is actually based on a different statute, 325D, that focuses on whether the same prior art or grounds that you're using in your IPR petition have been considered before by the office. So often you'll see this if a reference was considered during examination of the patent, then that may be an issue that you need to address in your IPR petition. The second one, parallel litigation, obviously that's what we're talking about today, but there are others as well. So follow-on petitions, you may have heard of this kind of like serial petition filing where one party files and then you see another petition on the same patent down the road with same or different grounds. Similar idea with parallel petitions, which are often filed by the same party. And then another point here, just emphasizing the board's discretion, is this idea of denying based on just a weak petition. And this is based on a couple informative decisions from the board. So for example, there's a case called Chevron Oronite versus Infinium. And essentially the reasoning is that even if a petitioner does show a reasonable likelihood of prevailing with respect to one or more claims, it's still discretionary whether the board wants to institute. So for example, the board can consider the number of claims that are at issue in the case and the number of grounds, and they can use that to decide whether it's essentially worth the effort and the time to go through and decide that case. So in, for example, that particular Chevron Oronite case, the petitioner had demonstrated at most that a reasonable likelihood of prevailing with respect to only 2 claims out of 20 that were challenged in the petition. So the board decided in that case that institution of all 20 claims, which of course is required under SAS Institute, would not be an efficient use of the board's time. So again, this is just kind of a very broad overview of these different types of discretionary considerations that the board is considering and taking into account when deciding whether to institute a petition. And certainly we could do a CLE presentation or more on each of these different categories, but today we're focused primarily on parallel litigation involving Fintiv. So let's jump to the next slide. So going to kind of where this started, this really came from a set of precedential board decisions. The first was NHK Spring, and this decision was made precedential in May of 2019. And at the time, certainly people were starting to talk about this aspect of the board's decision. It was giving practitioners some pause because there was this idea of looking at the timing of the district court litigation and how that affected the possibility of having your IPR instituted. But it wasn't considered kind of a huge sea change at the time because that wasn't the only reason for the denial. So in NHK Spring, there was also a lot of analysis about the 325D type of discretionary analysis. So the examiner, had previously considered some of the same references. So there was kind of another reason why overall the board decided not to institute. But the board did kind of preview what would come over the next 2 years. So the board indicated that the advanced state of the parallel district court litigation was an additional factor that weighed in favor of denying the petition. In that case, the jury trial was scheduled to begin 6 months before the final written decision would issue in that case. The district court had the same prior art and arguments, and the court had already construed claim terms. So these are a lot of key data points that we'll talk about through this presentation today. ironically, what ultimately happened in the NHK Spring case is the district court case ended up moving the trial. So this kind of basis for, this portion of the basis for discretionary denial kind of was undermined by the real world events and reality of district court litigation. But this was kind of the first indication that parties should be considering the timing of district court litigation in relation to the timing of a final written decision with respect to whether their case would be considered by the board. Okay, let's jump to the next slide. Okay, so again, NHK Spring was in 2019, and less than a year later, the major decision called Fintiv was made precedential in March 2020. So this very much expanded on NHK Spring, the same kind of reasoning about looking at the timing of district court litigation versus the timing of the final written decision in an IPR. And this actually was not an institution decision, just procedurally, it was a little bit unique. The board had authorized the parties to address the issue in that case, so the parties submitted briefing. And so this provided guidance, and it's a precedential decision that kind of goes through the factors that we'll talk about more today. But this actual decision was not the institution decision itself. But you can see we've included some of the reasoning from the Fintiv decision here. So just like we expected, NHK applies where the district court has set a trial date to occur earlier than the board's deadline to issue a final written decision. And the board explained that, you know, in looking at this analysis, there's different balancing considerations that go into that they take into account: efficiency of the system, fairness, patent quality. And so then the board set forth 6 factors and said they would take kind of a holistic view of whether the integrity of the system and efficiency is best served by instituting or denying review. So this kind of laid out the framework that we are all very familiar with now. And as we saw from those charts earlier, you know, 2020 is really when we saw kind of the biggest uptake in these kind of decisions. Okay, so let's jump to the next slide. So with this background in mind, these 2 precedential decisions, we can see kind of where things stand now as far as how much this Fintiv NHK type analysis is being used. So this chart shows the different types of discretionary denials, again, that we've talked about. So you can see, for example, the yellow color here represents parallel petition denials, and the royal blue color is really what we're talking about here, the NHK Spring Fintiv type of denials based on the status of parallel litigation. And you can see, again, this was not really a thing in 2018. It was hardly becoming an issue in 2019. And then in 2020, we just see kind of the skyrocketing numbers of use of Fintiv, and in 2021, obviously there's a significant number as well. So this is something that is still a very recent kind of development, but it is something that parties have adapted to and developed strategies for dealing with. And so we'll jump next into looking a little bit more in detail into those factors, and I will turn it back over to John.
Thank you. I just want to point out here that you can see on this slide that Fintiv denials are pretty much the same in 2021 as they were in 2020. So while there was an evolution, the number of denials really stayed consistent. What's interesting about this slide too, and I want to thank the folks from Unified Patents for this data, is that you can see that parties just stopped filing as many parallel petitions. There's a significant drop off in that regard, but the number of Fintiv issues remained. So we're next going to talk about the factors. And as Angela pointed out, this was, you know, no one factor is going to be dispositive. All these factors, the board is going to take a holistic view. And over time, we've seen that in some instances, the board values one factor over others. We're going to talk about that to a certain extent. But I'm going to walk through some of these factors just so we can see what are the important considerations that the parties have to address. And the first factor is whether the court granted a stay or evidence exists that one may be granted. So oftentimes, the parties have not either requested a stay or are waiting to request a stay until the board issues its institution decision. After Fintiv was made precedential, the board would often look to Fintiv Factor 1 as almost counting against the petitioner based on the stay statistics of certain district courts. So we know that a lot of district court, there's a lot of cases in the Western District of Texas and Eastern District of Texas, and they don't have the best, let's say, stats for granting stays. And so that would sometimes count against the petitioner. Now, what the board has done, though, over time is they've often find that this factor is neutral. The only time that it counts against either party is if there is specific evidence indicating how the board would rule. So if the district court, for example, would say, I am not going to grant a stay, I don't care what you do, that's going to probably count against the petitioner. Now, if the district court will indicate that if the board is going to, if the board institutes, I will grant a stay, that will count in favor of the petitioner. So the second factor is dealing with the proximity of the court's trial date. And this is really, this has became quite controversial because, as Angela pointed out, so many trial dates move, right? And that happened in NHK. In fact, it happened to Fintiv. I should point out that the Fintiv case that this all comes from, it still has not gone to trial. So this happened in March of 2020, and we're still waiting for that trial. What the board has done is they've looked at the scheduled trial date, and in the board's defense, that's really kind of all they can look at is what is the scheduled trial date. Now, there's been a softening of the board's approach to this, given the fact that so many trial dates move. The third factor is investment in the parallel proceeding, and we've gotten some guidance from the board on factor 3, and this is not just a total amount of investment. This has, if you look it's a Sand Revolution case we're going to talk about in a little bit, but that has to do with investment in the invalidity issues. So things like 101, things like venue, those don't always count as investment in the invalidity issues. What counts for investment is the party's briefing with respect to dispositive motions on invalidity and the invalidity contentions. Number 4 is also a very big issue, and that has to do with overlap. One of the overarching concerns is that you might have inconsistent results. There's this, the boogeyman is that somehow the board would find a claim to be unpatentable when the district court would find that same claim to be not unpatentable. And there's that overarching concern. The fifth factor is just the identity of the parties. The underlying premise behind Fintiv is that the petitioner really shouldn't get multiple bites at the apple. So you can't get an argument for invalidity before the district court and then present another argument again before the PTAB. And the sixth factor is really kind of a catch-all. I think it's significant that the merits is included in a catch-all. That's what the board should be considering at the outset. But anyway, that's there. It's the merits. And that often is found to be neutral unless there's a very strong, unless there's strong grounds presented by the petitioner. So we just went through the factors. Now we're gonna, and we can see here which factors are the most important. And this is over the last 18 months or 2 years, we've seen that factors 2, 3, and 4 have become the most impactful. So factor 2 is really just kind of a binary issue. If the parallel litigation is scheduled to go to trial first, that often will weigh against the petitioner. Now, this is a sliding scale. If the parallel, if there's a trial gap of only a few months, that slightly weighs in favor of denial. But if we're looking at 10, 11, or even 10 or 11 months or even a year, that tends to weigh more heavily against the petitioner. Factor 3, we talked about investment, and this really has to do with investment in invalidity issues. So if there has been a lot of investment in the invalidity issues, that tends to weigh in favor of denial. Now, this also is a sliding factor. These are all very fact-specific considerations. So we have one example. I'm just looking at a scheduling order, for example, in the Eastern District of Texas. Pretty early on, the parties have to serve, or the defendant has to serve its invalidity contentions. And a lot of times the invalidity contentions, some parties take the kitchen soup approach, right? And they throw in every reference that they think might be relevant to invalidity purposes. In the early days of Fintiv, that has sometimes weighed against the petitioner, because the petitioner then uses some of those references in the IPR petition. And so when you have that situation, there is some overlap in terms of the grounds that are presented. We can see also that other types of investment for Factor 3 deal with claim construction briefing and orders, invalidity contentions, fact and expert discovery, and dispositive motions. These are all types of briefing and investment by the parties that are considered by the board when weighing Factor 3. And then with Factor 4, which is what we're going to really focus on today, is the amount of overlap. As I mentioned, there's an overarching concern that if the board will consider the same validity issues that would be at play in district court, there is an overarching concern that there may be inconsistent results. So this next slide really kind of gives some information about why this is relevant, okay? So we see here the top 5 courts in the country for the number of cases, and this is all based on the percentage of cases filed nationwide. And we can see that Western District of Texas, about a quarter of all cases in the country are filed in the Western District of Texas. This has also attracted the interest of the Supreme Court. Justice Roberts pointed, he raised some concerns about how cases are assigned, and when they're assigned in the Waco division, that they might go to a specific judge. But we can see here that Western District of Texas is now the go-to forum for certain parties. Delaware, that has always been a forum where there is lots of attention, simply because a lot of corporations, they are incorporated in Delaware. Eastern District of Texas has been, they've been a big player in the litigation forum sector for a while. Their numbers have gone down since TC Heartland. You may remember in May of 2017, the Supreme Court decided TC Heartland, which had to deal with venue. Before that, in the 12-month period before TC Heartland, 36% of all patent litigation in the country was filed in the Eastern District of Texas. So that's significant. There's been a big drop-off. 3 months after TC Heartland, the number dropped for the Eastern District of Texas down to 13%. So we're seeing some consistency in terms of the numbers for the Eastern District of Texas. But what ultimately happened is the cases that were in the Eastern District of Texas, many of them went to the Western District of Texas. So we've seen that. And we can see here, and there's 2 California courts, because a lot of suits are targeting high-tech companies, and many of them are headquartered in California. So this next slide, we're talking about some milestones. And here, this is the average time to trial. And what's significant about this is that a PTAB case is 18 months from the time that the board issues a notice of filing date accorded. So it's usually within a week, 2 weeks, sometimes 6 weeks, where you get a notice of filing date accorded after a petition is filed. So 18 months from that point is when the board will issue a final written decision. We can see here that even if you file early on in 2020, even if you filed a petition the day you got served, in many cases, the Western District of Texas would have a trial for that patent, and that would have weighed in favor of denial. We can see here in some of the more popular forums that, like the Western District of Texas and the Eastern District of Texas, there are accelerated timelines. And for those who are involved in working on petitions, that getting a petition ready just doesn't happen overnight. It sometimes takes a couple months to figure out. You have to understand what the prior art is like, and then you have to put together your challenges. So it can take a couple months to get this really going. And when you're taking that into play with these trial dates, you're sometimes working against the clock. Now, I will say that the numbers for the Northern District of California seem a little bit out of whack from expectations. I think some of those numbers are COVID related, but anyway, these are the numbers that we pulled from Docket Navigator. So this next slide is another milestone, and the reason we included this here is because this is another significant milestone in terms of the briefing that the board considers, and that's claim construction. If the parties are addressing or briefing claim construction and the district court has issued a claim construction order, more often than not, that is going to weigh against the petitioner at the time of institution. There are some instances where it doesn't. For instance, if the board just issues a very short claim construction order that says that all claims will be construed according to the plain and ordinary meaning, that probably is not going to have too much of a bearing on the invalidity, the Fintiv considerations. But oftentimes, claim construction really has a bearing on invalidity arguments. And so if there has been briefing by the parties or there has been a markment order by the district court, that is going to weigh against the petitioner in terms of factor 3 for investment. So these are just some timelines that you can see that you have to take into consideration. So we talked earlier about Fintiv Factor 4, and I want to first address the kind of underlying concerns that the board expressed in relation to Fintiv Factor 4. So it's premised on avoiding overlap and potentially inconsistent results between an IPR and a parallel proceeding. So here's some quotes from the Fintiv decision. Says that the concerns of inefficiency and the possibility of conflicting decisions are particularly strong when the board is presented with substantial identical prior art arguments that were at issue in the district court. So what the board is trying to say here is that if you're going to present the same grounds in district court and then use those same grounds in your IPR petition, there's a possibility that there could be inconsistent results. And there's that boogeyman out there that we're all worried about how you could have different results in different forums. And that was an overarching concern behind Fintiv Factor 4. And here you can see the second bullet point, if the petition includes the same or substantially the same claims, grounds, arguments, and evidence as presented in the parallel proceeding, this fact is favored denial. And that's pretty encompassing because same claims, grounds, arguments, evidence, it's almost to the point where the board is saying, look, we are not going to allow you, petitioner, to have multiple bites at the apple. And what's happened is that stipulations have become an effective way to avoid overlap. So you can see here in the last couple bullet points, these are also, there's a quote here from Fintiv saying, conversely, if the petition includes materially different grounds, arguments, and or evidence than those presented in district court, this fact has tended to weigh against exercising discretion to deny institution. So if there are going to be different grounds or different claims, different considerations effectively, the board will weigh that against a discretionary denial. And so out of that statement, what developed is that petitioners started to stipulate not to raise certain prior art in a parallel proceeding. So you can avoid overlap. You avoid that boogeyman of potentially having inconsistent results. This was sort of the impetus behind this.
Okay, so I'll say,
go ahead.
So with that, we'll talk about a few different types of stipulations that parties have started using to kind of help avoid the problem that John was just talking about with respect to overlapping issues. So two of the types of stipulations here are based on an informative decision from the board and a precedential decision from the board. So the first type we'll discuss is called a sand revolution type stipulation. And this is essentially you're stipulating to not raise the same grounds. So you're not going to raise the same grounds that you raise in your IPR petition in parallel litigation. And again, that came from a case called Sand Revolution. We'll talk a little bit more about that in a minute. But just as an overview, a second type is called a Soterra style stipulation. And this is a much broader stipulation where the petitioner is stipulating not to raise in the district court the invalidity grounds in the IPR petition, plus any ground that the petitioner could have raised in the IPR petition. So this is much broader, and it looks basically like the estoppel language in Section 315E. And then aside from those two kind of mainstream types of stipulations, others have tried kind of hybrid stipulations that are somewhere in between. So, broader than the Sand Revolution style, but not as broad as the Soterra style stipulation. So this one, common example is a petitioner stipulating not to use the same primary references. So maybe you have one or two really good primary references that you've included in your IPR petition, and you use them, combine those with a secondary reference or two. And so the stipulation is, well, we're not going to use those same primary references in district court, but, maybe they would swap out, otherwise they could swap out just, a minor secondary reference or something like that and get around it. So they're saying, it's still a fairly broad stipulation to not use those same, really good primary references, but it's certainly not as broad as the Soterra style stipulation. Okay, so let's switch to the next slide and we'll talk about these in a little bit more detail. So first, focusing on the Sand Revolution type stipulation, again, this came from an informative board decision, and this is pretty narrow. And so, for example, in some cases, the board has found this not to be sufficient to overcome, but essentially the idea is the petitioner is not going to pursue precisely what it pursued in the IPR. So it does have the effect of avoiding, the conflicting decisions on the exact same grounds, but it doesn't come near the effect of essentially replicating the estoppel provision of 315E. So this kind of stipulation, the board has said, mitigates to some degree the concerns that underlie this discretionary institution analysis, specifically with respect to exactly duplicative efforts. But the board has also said, a broader stipulation might, have worked better. And so that's the Sand Revolution style stipulation. But switching to the next slide, the broader stipulation that a lot of parties have started using is the Soterra style stipulation. And this is the one that's very broad. So essentially, you're not going to raise anything in district court that you raised in your IPR petition or that you could have raised or reasonably could have raised in your IPR. So essentially, we're looking at any kind of arguments under 102 or 103. That's not applying to grounds that obviously cannot be raised in an IPR. So Section 101 is still going to be available in district court. So it's essentially limited to what you could have raised in your IPR. And this has been much more effective, as we'll talk about in a minute. But essentially, the board has looked at this kind of stipulation and found that this weighs strongly in favor of not denying institution. And so a lot of petitioners have used this very broad stipulation to really overcome this Fintiv analysis and move forward and go ahead and get their IPR petitions instituted. But of course, it does come with a cost, right? That's a big sacrifice to give up the 102 and 103 grounds entirely in district court. And so this is something that, PTAB counsel is often working in conjunction with litigation counsel to figure out what's best for the client in a particular situation based on the technology, what is the most effective forum for presenting these types of claims, and is this kind of broad stipulation going to be okay with district court strategy? Okay, so I'll turn it back to John to talk about the effectiveness of these types of stipulations.
Okay, yeah, thanks, Angela. So Soterra type stipulations, they are generally effective, and they have worked in many cases for petitioners. This is here we can see the Samsung Electronics versus Acorn This is a case that's often cited. Here, the board said that the petitioner Soterra type stipulation, it meaningfully simplifies overlapping issues between the parallel district court proceeding and this proceeding. I have encountered this citation many, many times in the board's decision. So if you want to flag this, this is something that the board often comes back to. And this is an explanation, of course, of Soterra. Soterra, as Angela pointed out, it weighs strongly in favor of this. But this other case here, the Samsung case, it is often cited by the board in explaining that this Soterra stipulation is good. Part of this is the fact that in Soterra itself, if you look at the facts of that particular case, the trial date, it's often called a trial, the trial gap, was only about a month, month and a half. Here, we have a 10-month trial gap, all right? So Samsung was early on in saying, look, this is very effective. This is also, just if you look at the timing, the Soterra case was in December of 2020 when it was made precedential. Here was an early decision dealing with a large trial gap of 10 months, and the board said, that's good enough. And so we've seen this. Now, we included some other examples, and you can see here that Soterra type stipulations have overcome trial dates with a wide gap. We've got a 10 month in 10 months overcome in Uber, another 10 months in the Tandem microelectronics case, 8 months, Bumble, and then 7 months later on. Okay, so Soterra stipulations are generally effective. There is one situation that I'm aware of where a Soterra stipulation did not work, and it was 11 months. So I don't know what you can discern from that, but 10 months, you're golden. You should be fine with a Soterra stipulation. 11 months, you might be stretching a little bit too far. But keep in mind that that 11-month case was also around March or April of 2021, and things have changed since then. I think as the board has become or moved away from, let's say, the previous administration and starting to look at this, we're starting to see a softening of Fintiv. So we can also see that Soterra stipulations are quite effective, even for ITC investigations. Now, starting in mid-2021, there was this explosion of denials in, or when there was parallel litigation in the ITC. And the reason for that is because most ITC investigations conclude around 16, 17 months, okay? So even if the petitioner filed it the day that they got the complaint, the ITC will always conclude before the PTAB would, okay? And that's kind of what's happened. Now, that has led to a lot of frustration on the part of practitioners simply because it was a sea change, right? Before, the board had said, well, the ITC doesn't have any statutory authority to cancel a claim. So even though the ITC might be considering invalidity issues, that doesn't mean that the ITC, though, can cancel any claims. As a result, we, the board, are going to hear this case because we feel like the petitioner has met its burden of showing a reasonable likelihood of prevailing. And then there was a sea change, right? Where all of a sudden, anytime there was an ITC case, denial, 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 denial. It was very frustrating. Then we introduce here Soterra stipulations. We've got a couple where it's not the 10-month, it's not the 9-month cases, but we've got some situations where Soterra was effective to avoid denial. So we've got the Okada group, that was 3 months. Shark Ninja overcame an ITC trial date that would occur nearly 2 months before the final written decision, okay? But you do have to overcome the overwhelming trend in 2021 of denials. And we've listed a couple here. These are a few, and these are not situations where it's 10 months out. In many cases, these were 3 or 4 months. This is just what you have to consider when you have an ITC investigation. So the trickier area is when you want to do a sand revolution type stipulation. As Angela pointed out, oftentimes you have PTAB counsel saying, hey, we really should get this case instituted, versus district court counsel who's saying, no, don't take any of my invalidity grounds away from me, right? And so there's some tension there. And you can see here, I don't want to give the appearance that there's a guide here, but the first three cases, we've got 3 months, 4 months, 5 months. So those sand revolution worked in that particular situation. 6, 8, 10 months, those didn't work for the sand revolution type stipulations. And if you dig into these decisions and the ones where the sand revolution stipulations did not work, it's the overarching theme here is the fact that you will still have a lot of investment up through the trial, and the trial is so far in front of when the board would issue a final written decision that it would be inefficient. So that's a word that you're going to see a lot when the board is trying to decide whether to institute or deny based on Fintiv is efficiency, okay? And the efficiency concerns were more prevalent when there is a larger trial gap and there's a sand revolution type stipulation. So then we have some examples about hybrid stipulations. Now, there is no precedent or informative decision based on hybrid stipulation. But as Angela pointed out, hybrid stipulations are broader than the sand revolution type stipulations, but they are, of course, narrower than the Soterra stipulations. Some parties are just unwilling to do the Soterra type stipulation because they feel like they have a really strong ground and they don't want to take it off the table. So what has come out, and some parties are doing this, and if you look at a lot of these cases, certain parties are using more hybrid stipulations than others, okay? And one thing I've seen is that generally speaking, hybrid stipulations are effective. I can't give you any sort of bright line guidelines here. We can see that a hybrid stipulation it overcame a 9-month trial gap. Microsoft had filed this, and there's some variations in terms of the types of stipulations. Here, the petitioner stipulated to forego any ground in district court that relied on the IPR primary reference. So let's say that the Smith ground, Smith is the reference that you use as the primary reference in your IPR petition. What a hybrid stipulation here, according to the one that Microsoft made, is that they said, we will not rely on any ground in the district court that also uses the Smith reference. There are variations even with that. Some hybrid stipulations will say, I will not use the Smith reference as my primary reference in district court. Others say, I will not use the Smith reference in combination with any other reference. So there's some variation here in terms of the hybrid stipulations. You can be creative, but your mileage may vary. I think that's the message here, is how creative you try to be. You might be going into territory that the board is not very comfortable with. So we can see in the second example, the petitioner used a hybrid stipulation to overcome a 5-month trial gap, okay? And then you can see here that it's a forego any challenge to district court that uses as a primary reference, the primary reference in the IPR petition. So that was a little bit narrower than the Microsoft hybrid stipulation, but it was still effective. And the broader one with Hulu, any grounds using the primary references from the IPR. So that overcame some concerns of the board by Hulu. But we see an example here where Verizon was not able to use a stipulation, an 8-month trial gap. There, the board felt like the trial gap was too much.
Okay, so with that, we can see what's the current status. This graph kind of shows the last 6 months of institution decisions and what we're seeing on that front. And just to explain it in a little more detail, so the orange colors here are the number of institution decisions that have discussed Fintiv, so on the particular topic we're talking about. And then the blue color represents cases where institution was granted. So you can see in every case except for one in August, something has shifted. This is working. The different types of stipulations, the changing attitudes about this, things have really shifted with respect to Fintiv. And so there are ways now, if you're careful and plan your petition and coordinate with district court counsel strategically, it looks like Fintiv is becoming less of a problem with these strategies in mind. Again, so every case except for one in August, we was able to get an institution decision despite Fintiv. So let's switch to the next slide, and we'll just talk about some practical tips, both for the patent owner side of the story and for the petitioner side as well. So on the patent owner side, I think one of the best strategies is to really scrutinize the stipulations that petitioners are presenting. So as we've seen, these stipulations are effective. They're working, particularly the Soterra style broad stipulations. But when parties try to kind of tweak the language or make it a little different, or maybe incorporate some other idea or concern they have about something into the stipulation language, things can go awry. So here's an example of one case. This is immersion systems versus Midas Green Technologies. And the stipulation in that case from the petitioner looks very close to others we've seen, but it basically says they stipulate that if the PTAB allows them to enter the stipulation and institutes review that results in a final written decision, then they would forego certain claims. And the board here kind of picked at the specific language in the stipulation and said that this was very different from other types of stipulations the board had relied on in the past to move past Fintiv analysis. And so the board actually found in this case that the stipulation would not affect the overlap with invalidity grounds in district court because the trial was 4 months before the final written decision, as you would expect in the Fintiv analysis, because this particular stipulation was contingent on entering a final written decision. So this is an example of how patent owners, one strategy is to kind of look very closely at the language being used and see if it matches the types of stipulations that the board has been comfortable with, or if there's something else that the petitioner is trying to do with the stipulation. So that's just one kind of broad tip for patent owners. Let's turn to the next slide. Another tip for patent owners who are trying to avoid institution of an IPR petition is to really focus on the investment in the district court litigation. And that, of course, as John has talked about earlier, is one of the factors that goes into the Fintiv analysis. And if there has been a lot of investment by the parties and by the court in district court, then that is going to weigh in favor of denying the IPR petition. So the key here is that patent owners have to tie these arguments to investment in the invalidity issues and that are relevant to the IPR. So again, you should be looking at things like deadlines regarding invalidity contentions, deadlines regarding amended contentions, looking at the Markman order, Markman briefing. You can kind of get a preview from the briefing if the issues are going to be impacted, or if the issues there are going to impact the invalidity analysis in the IPR. And so there's a lot of different pieces there that can come up in the district court litigation, right? I mean, you can be creative here and look at a lot of underlying things that are happening in district court too with respect to discovery and experts and things like that. So that's another strategy that patent owners can use here. So just an example or two. So in the Stand Revolution, the board found that aside from the Markman order that had issued, a lot of the district court investment was not related to invalidity. So that was not as persuasive in that case. Again, the the overarching concern here, right, is overlap on invalidity analysis. So even though the parties are obviously pursuing their infringement case in district court and doing a lot of other things, that itself is not going to be relevant to definitive analysis as much as the invalidity analysis and focus will be. So another example is this Hyundai case. And here the parties briefed claim construction and the district court had issued the Markman order. And the board found that the claim construction briefing and Markman did not indicate the type of significant investment that would support denying institution. And the board particularly noted that the parties didn't advise the board with respect to whether the issues in the Markman hearing had any bearing on the challenged claims and grounds in the IPR proceeding. So again, even within the realm of invalidity, try to focus on what is specifically at issue in the IPR to create some kind of story about overlap in work between the two proceedings. And that's the kind of duplication and extra effort that the overarching concerns underlying defensive analysis are really designed to address.
So,
okay,
Angela, if I could just chime in here, one example that I see quite a lot is where the parties argue that a claim is indefinite in the district court, right? And indefiniteness is not something that a petitioner can raise in an IPR. And in those situations, the board has said that that doesn't relate to the invalidity issue at play in this petition, right? Which can only be under 102 and 103. So that's just another kind of a example where the invalidity issue is you're dealing with, of course, claim construction, and indefiniteness is a form of invalidity, but it's not something that you can raise before the board.
That's a great point. Okay, let's jump to the next slide then, and we'll talk a little bit about petitioner side strategies. So, as you can probably have guessed, what we're focused most on today was these stipulations. So really consider whether you can commit to the broader stipulation. As John discussed earlier, the narrower stipulations, the hybrid stipulations, there can be a lot more variance in how those come out. And the overarching kind of pattern with respect to the broad Soterra style stipulations, that those are much more effective. Now, I do have to mention that we prepared this presentation prior to the recent decisions in the Federal Circuit in Caltech versus Broadcom. And if that's something that the members of the audience have not had a chance to read yet, I highly recommend reading that opinion. Make sure you also read the errata to that opinion that came out this week. There's an important clarification there. But essentially, the Caltech versus Broadcom opinion overrules the older case Shaw that we were previously familiar with respect to the scope of estoppel in district court. And so consider that. I think that kind of impacts the type of stipulation that your client may be willing to consider with respect to IPR petitions in light of the eventual estoppel effects that could come from an IPR down the road. So just one more thing to consider.